Hello, I would like to welcome you to our webinar on important family law cases in 2024 and 2025, which is hosted by METRAC Action on Violence with guest speaker, family law lawyer Victoria Kyle. My name is Andrea Collins Fitzpatrick, and I'm the legal director with METRAC. I would like to begin today with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. This webinar is for general information purposes only, and it is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. This webinar will be recorded and reflects developments in the law before today, March 25th, 2025. It will be posted on our website at onefamilylaw.ca, that's onefamilylaw.ca, along with the PowerPoint slides. Before I move to our presenter, I would like to tell you a bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, that's onefamilylaw.ca, for more information on your family law matters. I'm very excited today to have Victoria Kyle to speak to us about important family law cases from 2024 and 2025, and thank you for joining us today. Before I introduce our presenter, Victoria, I would also like to thank Ken Yan, our Justice Program Coordinator, for running the PowerPoint presentation today, and as always, our technician, Fernandette. I would now like to introduce our presenter, Victoria. Victoria was called to the Ontario Bar in 2020. She obtained her JD from the University of Ottawa, and her legal studies focused on issues of access to justice and intimate partner violence. Victoria practices in the area of family law, first at a boutique practice in Ottawa, and more recently as a sole practitioner in the Greater Toronto area. She has specialized experience assisting clients who are survivors of family violence navigate the family law system. Please enjoy the presentation, and I'll now pass things on to Victoria.
Thank you, Andrea, and good morning. Thank you for having me today. Today we'll be covering 3 topics. The first topic being intimate partner violence and shared parenting, and hearing the voices of alienated children. That case is Chyher v. Jaboury, 2025 ONSC 998. The second topic will be regarding litigation abuse and cost decisions in Kumar and Nash, 2024 ONSCJ 16. And finally, parenting orders for adults with disabilities and their right to participate in matters concerning themselves, with the case being JFR v. KLL, 2024 ONCA 520. And finally, we'll be discussing some resources available. The first case is Chyher v. Jaboury. The applicant and respondent in this case have 2 sons, AG and SG, who are 11 and 10 at the time of separation in 2020. The applicant mother was the primary caregiver for the children. They had a very close and loving relationship at the time of separation. In particular, as the eldest son began having seizures in or around 2018, after this time, if he was not in school, he was in the care of the applicant as he required close monitoring. The respondent father worked long hours as a taxi driver, being outside the home most days from 4 a.m. to 6 or 7 p.m. with no days off. The separation occurred in or around July 22, 2020, after a culmination of incidents of IPV, including physical violence, as well as control and isolation. The applicant gave evidence at trial of incidents where the respondent exerted negative influence on the children, which impacted their relationship, including surrounding her decision not to wear a hijab. After an argument on July 22nd, the applicant went to pack a bag to leave the home, and the respondent had the eldest child call the police. When the police arrived, they spoke with each party and the children in the presence of the father. The police report notes that the respondent has expectations that the applicant remain in the home with the children, not to work to ensure the daily household chores are completed. He got angry today because she went out to a kickboxing class and was gone for too long. The respondent felt that the applicant suffered from mental health issues and should go to the Royal Ottawa. The respondent detailed to the police the fact that the parties had not slept together in approximately 1 year, and he had a medical condition which made this painful. The police notes further noted that the children were never far from the respondent, and that the children stated the applicant was a liar. At one point, the youngest child, S, made a comment that he thinks his mother's in love with someone else. The police specifically noted that prior to leaving, the applicant put a calendar on the wall which outlined the eldest child's medication schedule. The applicant left the home with the assistance of the police and went to stay with a friend on their couch. The children remained with the respondent as she did not have a place for them to stay and had been told false information about the safety of shelters for children by the respondent. The applicant understood at the time that she could have the children enter her care when she had a safe space for them to live. Within days of leaving the home, the applicant began trying to see the children and have them returned to her care. However, the respondent would only allow parenting time in the matrimonial home and monitored all phone calls on speakerphone. The respondent further contacted the applicant over 80 times in one day. He told her to come home to see the kids and to fix the problem. And the phrase "the problem" comes up throughout this case and is used by both the respondent and the children to refer to the applicant leaving the home. The CAS met with the family immediately following a separation because of their police involvement, and again about a month later. At trial, the CAS notes were used by the court to understand the children's state of mind after only 1 month of no contact with the mother. Specifically, the children claimed at the second meeting with the CAS that the applicant would hit them every day when in her care. The CAA asked why this had not been raised at their first meeting, and the children stated that they had raised it then. The children stated that they did not want to talk to their mother or see their mother. They said that the mother had tried to kill the eldest child because she took his medication. The applicant tried to arrange phone calls with the children through their martial arts studio. The whole family had attended classes at this studio for many years, and specifically, the mother and children attended class there multiple times a week. The children refused to speak with the mother. They repeated the same claims that they had told the CAS. The teachers at the studio noted at trial a significant change in the children's behavior in the months since separation. For approximately 5 months, the applicant was unable to speak to the children on the phone or in person. She had served her application in August of 2020, but the matter was not able to be heard until an urgent motion in December. The respondent provided no evidence at trial as to why he did not allow any parenting time, and rather stated that he had offered parenting time at the home. On December 22nd, at an urgent motion, the motions judge ordered that the children reside primarily with the applicant with a specified parenting schedule. The respondent submitted at the motion the children's claims with regard to the applicant having physically harmed them. However, the motions judge was not persuaded by the evidence that the applicant had harmed the children and found it more probable that the respondent was exerting negative influence. After multiple failed attempts to have the children enter into the mother's care, they finally entered into her care on December 24th. This is a quote from the trial judge, which stated, "What occurred next can be described as nothing less than a nightmare for the applicant. The children, who had previously been sweet, loving, and affectionate with her, shouted at her, did not listen to her, and did not show any affection. They were exceedingly rude to her and refused to call her mom." During this time, the respondent was texting and calling the children on the hour and would be upset and yell at them for not calling or answering the phone. Eventually, the applicant was able to get the calls down to every 2 hours. The children were very angry at her and blamed her for everything, and they were especially difficult after visits with the father. The applicant described on one occasion when the kids were speaking to the father on the phone while in the car, and he stated to them, "Go home, the police are coming." Upon arriving at the home, the applicant was met with 3 police officers and the CAS. The applicant indicated at trial that the police or CAS were involved with her on 5 occasions after the children returned to her care, and that the children ran away on 3 occasions, once to a nearby Tim Hortons where the respondent was present with them, once away from the house only to be found nearby with the respondent, and once again from their martial arts studio and to the respondent's home. Next slide, please. The exceedingly difficult behavior of the children continued. A parenting assessment was completed on September 3rd, 2021. Next slide, please. From the parenting assessment report, the assessor noted that the respondent exerted enormous amounts of pressure on the applicant and the children to do his bidding through telephone calls to the children post-separation. He incited the children to disobey their mother, to stand up for their rights, no matter who was telling them otherwise. The respondent showed no insight into the negative impacts of these behaviors on the children or their relationship with their mother. Concerningly to the risk assessor, neither children could describe anything positive about their mother, and it was increasingly concerning that AG, the eldest child, had made comments on several occasions that he wanted to kill his mother. The assessor found that the respondent deliberately sabotaged AG and SG's relationship with their mother. Next slide, please. Within the report, the assessor notes that true forms of parental alienation are rare, much rarer than clients would have us believe. However, there is no question the respondent's behaviors and attitudes have caused the children to reject their mother. Next slide. A motion for supervised parenting time was brought in December of 2021. Following the release of this report, the motions judge found that the respondent father required supervision in his parenting time for the best interest of the children. The motions judge stated, "I have come to the clear and unequivocal conclusion that the children will be at risk of severe emotional harm if the current parenting arrangements remain in place for any length of time, and if the children do not immediately access the services that they need to repair the damages they have already suffered and avoid the complete and irreparable breakdown of their relationship with their mother." Next slide. After this motion, when supervised parenting began, the applicant began to see a change with the children within 2 weeks. The children became more relaxed. They had less tension after returning from parenting visits. The applicant was still experiencing anger from AG, but things were improving to the point of having a nice time. She noted at trial that while AG was still resistant to hugs or kisses, he would accept a scratch on the back as a form of affection. Supervised parenting continued until the matter returned for trial. Within that, the parties agreed to update the parenting report in March of 2023, 2 years after the first report was made. Next slide. This update to the parenting report was completed in November 17th of 2023. In this report, the assessor notes that she remained concerned with the respondent's behavior and influence on the children. Specifically, the assessor notes that A is stuck in the past with his parents' relationship. He continues to refer to the separation as the problem, just as he did in 2021. That A continues to blame his mother for the separation and cannot see how his father has any responsibility. The assessor notes that this is a wholly unbalanced view and not what one would expect from a 14-year-old child. A idolizes the respondent and stated that his father taught him everything in life, and he is unable to acknowledge his mother's love and devotion to him as well. The assessor notes that A is still angry with his mother, although he seems conflicted about how to feel. He is unable to say that he loves the mother, but at this point, he did not want her to be hurt if he said that he did not love her. A is unable to determine if one can be angry with a person and still love them. S also carried strong emotions, which is not different from what was reported in 2021. He continued to occasionally cry at night because he misses his father, and often he is unable to articulate why he is crying. The assessor was greatly concerned that although the respondent appeared to have been making a concerted effort to curb his comments to A and S during his supervised visits, he continued to undermine her, often in subtle ways that over time, she says, were quite insidious. Within that, there were 6 pages of examples from different supervision notes outlining these occurrences. The respondent's continual, often subtle, undermining of the applicant keeps the boys in a state of confusion, high drama, and duplicity. The fact that the same concerns were raised in September of 2021 by the assessor was very alarming to the trial judge. The difference between then and now is that the respondent is not making overt comments, but rather his comments are covert. The assessor noted serious concerns about the respondent's flagrant disrespect of the court order by having contact with A and S without supervision and without the applicant's knowledge. The assessor remained concerned at that point about the respondent's ability to make change. With this report, the assessor included recommendations that supervised parenting time remain in place until December of 2024, when the youngest child turned 14. She was asked why and indicated that it was to mitigate the respondent's negative influence and to allow the applicant to continue building her relationship back with the children. She considered the children's expressed views and preferences in coming to her recommendation, and it was her view that what they wanted, which was a shared parenting regime, was not in their best interest because it would not support their relationship with their mother. It was her hope that by continuing the supervised parenting time until the youngest was 14, that at that time, both the boys' relationship with their mother and their level of maturity would be strong enough to sustain the gains made in the past 2 years. Next slide. The OCL was appointed prior to trial to represent the children. The OCL relied upon a 2023 article by Ian Ross from the Canadian Family Law Quarterly entitled Beyond Lip Service. And although this article was written in the context of CYFSA proceedings, the CAS submitted that the principles are equally applicable in family law proceedings. On the issue of influence and/or alienation, the report notes that the question of attributing weight to a child's view is not whether the child has been influenced by individuals in their lives. Rather, increasingly weight is given based on the child's age and their increasing capacity to understand the decision being made and its consequences. Reference was also made by Mr. Ross to cases of alienated children, and he stated, in the few severe cases where a child can be said to be truly alienated, courts must consider the implications of not listening to the child's views. The wishes of an alienated child may be warped and misconceived, but they are nonetheless real. Even for an alienated child, telling them that their views were not heard or given weight can still cause them to feel ignored and lonely, be sad or experience anxiety and fear, or be confused and angry at being left out, or be less compliant with the order and vote with their feet. As such, courts should be extremely cautious before silencing a child's voice by finding that the child's views cannot be asserted and should be given no weight for matters that affect them. Next slide. So at trial, there was a finding of intimate partner violence and a finding of parental alienation by the respondent. The trial judge noted even more insipid were those instances of physical violence and/or intimidation was the coercive and controlling behavior, be it financial, sexual, or emotional, employed by the respondent during most of his relationship with the applicant. There is no doubt that the respondent, despite his protests to the contrary, that he severely alienated the children from the applicant. Fortunately, through the intervention of the court in December of 2020 and December of 2021, and all the hard work, perseverance, and dedication of the applicant and the professionals with whom she worked, the applicant's relationship with the children has been restored to the degree which it has. The order was made that the parents shall have a shared parenting schedule with the children, and it was because of their views and preferences that this order was made. Sole decision-making was awarded to the applicant, however. Next slide. With this in mind, Her Honor stated that the respondent may consider that he is a successful party in relation to the outcomes of this trial. He is not. Rather, it is the expressed views and preferences of S and A, who are now 14 and 15 years of age, respectively, which have ruled the day. The next case is Kumar and Nash, and this is concerning litigation abuse and cost awards. So first, to define litigation abuse, it is a pattern of misuse in family court process that could reasonably be expected to cause distress or harm to the other party or the children that is greater than what would occur with the proper use of the family justice process. While instances of misuse of the court might be due to an innocent mistake, when viewed cumulatively, there may be a pattern of conduct that is abusive and causes unnecessary stress and expense to the other party. This can occur because the procedural requirements of the family court may provide an abusive partner with an opportunity to use the legal system to continue to harass and control. The abusive partner can take advantage of the fact that legal proceedings allow continued direct contact with their victim over an extended period of time. The requirements of family court processes generally compel victims to interact with their abuser, to answer invasive questions, to counter false allegations, and to provide evidence of their partner's abuse and may provide ample venues for re-victimization, especially if the parties are self-represented. As the literature recognizes, litigation abuse not only harms the direct victim, the former partner, but also the children who are subject of the proceedings. Children are at risk of being harmed by the tactics that prolong the litigation, which adds to their distress and depletes financial resources that could be used to meet their needs. Litigation abuse also clogs, disrupts, and delays the court system, imposing delays on other users of the court systems and the taxpayers. In Kumar and Nash, on December 1, the parties brought a parenting motion for their 2-year-old son. The applicant father also sought a restraining order against the respondent mother's counsel and an order to remove the counsel from the case. Justice Chyher dismissed the applicant father's motion and granted the respondent mother's request to have the father's parenting time be supervised. On December 4th, the applicant father brought a motion in writing to set aside the order or to rehear the motion. He also sought unsupervised parenting time. On December 13th, the court dismissed the motion and found that the mother was entitled to costs. The court further endorsed that the father be required leave of the court to bring any further motions. The next day, on December 14th, the father brought another 14B motion seeking leave to bring a motion for the same relief. On December 22nd, the motion was dismissed. The court endorsed that the father's conduct was bordering on an abusive process and that he was wasting valuable court resources. The father was ordered to pay $565 in costs to the mother for that motion. The mother sought full recovery of costs at $15,019 for the December 1st and 4th motions and alleging bad faith. She further sought an order that the father not be able to file any documents until the court costs are paid in full. The father, in response, sought to set costs at $1,500 and sought that it be payable in installments. For the case Matina and Matina, there are 4 fundamental purposes of a cost award, and they are to partially indemnify successful litigants, to encourage settlement, to discourage and sanction inappropriate behavior by litigants, and to ensure that cases are dealt with justly under Section 2.2 of the Family Law Rules. Subrule 24.8 of the Family Law Rules states that if a party has acted in bad faith, the court shall decide costs on a full recovery basis and shall order the party to pay them immediately. This section requires a fairly high threshold of egregious behavior, and as such, a finding of bad faith is rarely made. In this case, the court found that the father had acted in bad faith regarding his motion seeking a restraining order against the mother's counsel and ordering her counsel be removed from the record. The father made unwarranted allegations against the mother's counsel, alleging that she had fabricated evidence and weaponized the police to keep him away from his child. The court found in its oral decision that the father doubled down on his attacks against the mother's counsel in his subsequent Form 14B motions, and that malicious attacks of this nature, without any evidentiary foundation, cannot be condoned by the court. That such attacks undermine the integrity of and respect for the administration of justice. The court stated that serious consequences should follow when litigations choose this path. Thus, the court found that $3,000 of costs arose from his bad faith and must be paid immediately as required by Subrule 24.8. The court took the father's financial circumstances into account by deferring the remaining $7,000 costs payable in monthly installments. Next slide. This matter concerned a self-represented litigants, as family cases so often do, and some interesting research has been conducted to consider the role of counsel to manage litigation abuse. In the article Exploring Litigation Abuse in Ontario, an analysis of cost decisions, there was a significant relationship found between being a self-represented litigant and a finding of litigation abuse. Specifically, of the 39 cases where female litigants was an SRL, which is a self-represented litigant, she was found to be engaging in litigation abuse in order to pay costs in 44% of the cases, in 17 out of the 39 cases. In comparison, of the total 365 cases where a female litigant was represented, she was found to be engaging in litigation abuse in order to pay costs in 23% of those cases. Of the 68 cases where a male litigant was self-represented, he was found to have engaged in litigation abuse in order to pay costs in 54% of those cases. In comparison, of the total 332 cases where the male party was represented, he was found to be engaging in litigation abuse in order to pay costs in 23% of those cases. The final case we'll be discussing is JFR v. KLL, and that's regarding parenting orders for adults living with disabilities. This case was an appeal of an interim parenting order. The parties had separated in 2012 and signed a separation agreement with shared parenting provisions for their 2 children. M is 26 years old at the time of this appeal and living with Down syndrome. He continued to follow the shared parenting schedule even after he was no longer a minor. However, during the COVID-19 pandemic, the parties agreed that M would live primarily with his mother to limit his exposure. Then, beginning in October 2020, the father sought to return to the shared parenting schedule. When that was not successful through negotiation, he ultimately brought an interim motion seeking to restore the 50-50 schedule. Next slide. M was not present at the interim motion, nor was he represented by counsel. At the interim motion, the court determined that they had jurisdiction to make an order regarding M's residence because there had been a recent assessment by Developmental Services Ontario, which determined that M required supervision and support to protect his health and safety. The court determined then that he was a child of the marriage under Section 2(1)(b) of the Act. The motions judge ordered a temporary parenting schedule that was shared pending the final order. The judge also ordered that the parties obtain a social worker or psychologist to speak with M to obtain his views and preferences regarding his residence. The Substitutes Decisions Act of 1992 finds at 2(1) that a person who is 18 years or more is presumed to be capable of entering into a contract. The onus to prove incapacity rests with the party disputing it. The determination of legal capacity are domain and decision specific. This recognizes that a person can have the ability to make some decisions and not others. For example, a person may not be capable of making decisions regarding their finances or property, but can still make decisions about their personal care. So there are specific tests of capacity for different types of decisions. It is a rule of natural justice that requires courts to provide the opportunity to persons who are affected by a court's decision to be heard. Failure to do so is a breach of natural justice. The court, in this appeal decision, found that dependence on others does not eliminate the right to be heard. The right to make decisions about one's own life is fundamental to autonomy and personhood. The fact that the motions judge ordered the involvement of a social worker in fact recognizes this need to hear from M, but the Court of Appeal found that a social worker does not substitute for M's right to participate as he is presumed capable as an adult. His views and preferences cannot simply be ascertained by a social worker. Thus, the Court of Appeal determined that before an order can be made for an adult under Section 16(1) of the Divorce Act, the court must determine whether the adult is unable to withdraw from parental control. Next slide. The Court of Appeal found that in the absence of a prior capacity determination, an adult who is presumed to be capable under the Substitute Decisions Act and who is potentially affected by an order should first be served with notice of the proceedings and second, have the opportunity to obtain independent legal representation and participate fully in the proceedings. The court is cognizant that the determination that an adult person is a, quote, child of the marriage may diminish that person's right to function autonomously, including, as with this case, deciding where, when, and with whom they live. The court also called attention to the unfortunate nature of the term child of the marriage in this context as it relates to adults with disabilities, as it obscures the presumption of capacity that applies to all adults. While it was established that M cannot live independently and requires financial and other support, at the temporary motion, it was not established that he was unable to withdraw from parental charge in relation to decisions about his residence. There was also no order declaring him incapable of making personal care or property decisions, nor was there a guardianship order in place under the STA. The Court of Appeal found that absent such evidence, parenting order regarding M's residence could not stand. The court further noted that M's lack of objection to his current living arrangement, or even his present willingness to live with either of his parents, does not mean he agrees to be bound by an order compelling him to live with each of them at particular times. As a result, the appeal was allowed, and the court set aside the parenting orders of the motion judge with respect to M's residence, including the cost order. The Court of Appeal noted that if the parties wish to pursue a parenting order under the Divorce Act to determine M's residence, he is to be added as a party and ordered that he be represented by counsel. Thank you.
Thank you, Victoria, for that very informative presentation on some interesting family law decisions from 2024 and 2025 on the issues of intimate partner violence and shared parenting, where the issue of parental alienation was discussed. Also, it was very interesting to learn about the case on litigation abuse in family law matters, particularly the discussion about self-represented litigants being involved in litigation abuse, and finally, the discussion on parenting orders for adults who have disabilities and their right to participate in the court process. I'm sure we're all much more informed about some of the latest developments in family law cases in Ontario. We also have on this slide some resources that would be helpful if you're looking for more information on family law matters in general in Ontario. Thank you and take care. Bye for now.